Hello everyone. Welcome to Simplified Approach to Drafting Contracts. My name is Walid Hassanin and I will be your instructor today. Now, here's a surprise quiz at the start. Your client approaches you and wants you to draft a contract, organizing a relationship. He is an investor and he has €1 million that he wants to invest. And he has another friend who is a patent holder, medical researcher, who made a new patent for a new antibiotic or probiotic medications. And since the €1 million will not be enough to create a medical company or pharmaceutical company to manufacture this probiotic or antibiotic medications, they decided to go to a pharmaceutical company that saw the promises of the sales for this antibiotic medications and offered them to a space to manufacture that antibiotic medications using the €1 million in financing the production line for said medicine. And they all agreed to split the profits of this antibiotic medics by percentages until the €1 million are returned to the investor, and then change these percentages later, like in this quiz, for example. I will leave a link below. So it's important to bear in mind that you can't just have a contract, a sample, and then rely on it, because in real life you will not get simplified or simple relationships like that. It will have sample contracts for it. You will have a very complex relationship, and they will ask you to organize all the relationship in one contract. So let's bear that in mind. Now, just imagine this. Your client approaches you and he tells you, draft me a contract. What will be your first words to say? You will not sit by the desk and start drafting because you don't have any information. And what will you do? You will ask, well, what kind of a contract? What's the relationship of this contract? And he will tell you, a sales contract, for example. And then you will ask, well, who are the parties? And he will tell you that I am the seller and my friend will buy my car. So you will ask, what's the item being sold? And he will say, I just told you, it's my used car. All right. So you will tell him, okay, more details about the car. And he will provide you with make, model, color, VIN number, license plate, and so on and so on. And then you will ask him, what's the price? And how the payment should go, how the delivery should be, and so on and so forth. So by attributing the clauses to elements of each contract, you will be able to remember the contract elements without needing to memorize the contracts itself. So you will have to create your own question to ask about the information needed To understand that, let's see what is a business relationship or a contract. Well, as you can see, it's simple. To simplify it, it's an exchange. Party A, party B. He has something that he wishes to exchange with the other party for that other something, right? Buyer will exchange cash for goods and the seller will exchange goods for cash. And that's simply it. Other types, it can be services. And there is obligations and rights, or covenants and rights, entitlements. And it might seem to you that there are different parts. However, it's a relative term, meaning the buyer is entitled for the car to be in said condition, and the seller is obligated for the car to be in said conditions. And therefore, obligations and rights are merely a relative term, depending on the context of the situation. If it's about the car condition, then it's an obligation for the seller and a right for the buyer, and so on and so forth. So let's further go more. Let's review a great example of a bad contract drafted and a good contract drafting. This is an example of a bad contract. Now, did he state the parties? Yes. Did he set the description of the items? Yes. Did he set the price? Let's check. Description, vendor, disclosure of warranty, line holder, name, buyer, selling for the price. And here it is. And then signature. So why is this not a good contract or a bad drafted contract? Well, yes, we need to simplify the contracts. However, oversimplifying will lead to problems. For example, selling at the price of vehicle, amount of dollars. Did they set how the payment should be paid, will be paid, must be paid? Nope. So they didn't say if they would be paid in cash or installments, or if there will be installments on when. And they didn't even set the applicable law for dispute resolution. What will happen if force majeure happened? All that is missing. Now, let's see a good drafted contract. This is an example of a good drafted contract. First, here's the title, and then identifying the parties, seller, buyer, and then identifying the goods, quantity per delivery, tolerance percentage. If you don't know what tolerance percentage is, basically, for example, if the goods will be divided in multiple units, what would be tolerated in loss or non-conformity. All right, and then delivery of said items, price and payment conditions, and then documents, and then in case of a breach, lack of conformity or non-conformity, transfer of property, avoidance of contracts, and then force majeure, entire agreement and notices, dispute resolution, and applicable law. As you can see, this is a good drafted. Not well, but good. Why did I say that? Because 1. The price and payment conditions should be contained in one clause. Why is that important? To avoid vague and avoid any indiscrepancy. And delivery should be included with goods because you identify and then you specify the delivery, method of delivery. And then the documents should be attached to the delivery. And non-conformity, non-performance, or none for each seller and buyer should be along with the lack of conformity to the avoidance of contract. Paragraph 1 to 3, sub to paragraph 10. And then you leave the force majeure as it is, and entire agreement notices applicable law and dispute resolution. So this is basically a very well made contract it will be. Alright, let's go back to the class. So as you can see, if you understood the basic elements for any contractual relationship, you will be able to specify questions to inquire about the information of these relationships. Later on, for other sessions, next session will be the company's law. We will be analyzing the different types of relationships between the parties to form these companies, and then it will be up to you to set the questions on how to ask about the elements of the company's relationship. Now, let's take this example. Your client is Industrial Robotics in the United States of America, and the other party is Fiat Cars in Torino, in Italy. And they have agreed to sell 6 car assembly robots to Fiat in Torino, in Italy, on 2 shipments in exchange for $3 million, which will be transferred into installments. And this is how your client will approach you. He will not tell you, draft me a sales contract for 1, 2, 3, 4. He will tell you a story, and you will have to extract this information from his story. Alright? So, what elements we have here? Well, we have 1, parties. So basically these are the who, and then we got the title, which is sales or what. Alright, and then we have the goods, and then we have the price, method of payment, method of delivery, where, and we got the when, and we have the how. So it's up to you to use these questions, the who, what, when, where, how, to organize your questionnaire to draft the contract. Simple as that. Therefore, I want you to draft the contract using the sample I'm going to leave in the description here, this sample, and apply that to the case studies that I'm leaving you here. That your client is Industrial Robotics USA, and you have Fiat Italy Torino that is interested in 6 car assembly robots in exchange for $3 million on 2 installments, and the robots will be shipped in 2 shipments. Alright, apply that and let's see what you will do. Okay, so basically when you consider all that, you will have this shape. You should expect this shape. Clause 1, parties. who are the parties, and clause 2, the goods with the specification. Clause 3, price payment with installments or more details on the payment. And then delivery and documentation is needed. And then avoidance and remedies for such relationship. What will happen if A breach their obligations, and what will happen if B breaches their obligations. And then the applicable law and the dispute settlement procedures. Why is remedy is important? Because as you can see, business is a flexible relationship. And that's why in all common law, they left organizing the business's relationship to the parties, because the contract is the law drafted by both parties. They want to oblige themselves with it. Therefore, if you draft it very firm, what will happen is that you will create a problem in the future that might result in the contract not being executed, which will hinder the process. Now, what is more important also is, after understanding the basic elements of a contract, you need to understand the wordings, the use of words. Let's analyze that. This is the quiz, and this is, I don't know that. This is course syllabus. What do we mean? I think it was here. Nope. Ah, yeah. So, for example, you can use active sentences, but don't listen to this advice where they say avoid passive. Actually, this is a wrong advice. I will show you later why. For example, when the employees return to duty, leave balances are reconstructed and any leave fortified is restored. This is a passive form and this is an active form. When the company returns the employee to duty, it reconstructs leave balances and restores any fortified leave. Now, another advice is keep sentences short. Alright? For example, take this one. It has been determined that this is not a major amendment under the EU directive because this amendment will not result in an annual effect on the economy of 100 million or more, or a significant increase in costs for consumers, industry, or community, member states, or local government agencies. Now, you could read as 3 short sentences. This is not a major amendment under EU directive. It will not result in an annual effect on the economy of 100 million or more, nor will it significantly increase costs for consumers, industry, community, or member states, or local government agencies. So it's totally up to you to keep the sentences short. However, don't neglect any information. Now, they will go on and tell you to keep your contract firm and not flexible, using active and passive and firm and loose terms. Now, as you can see, in these wordings of this contract, you will see that the use of shall, the seller shall, is a firm wording. However, in some cases, they say parties may choose, and may is not firm as shall. because that's important, because if we put affirm clauses, as I said before, any nonconformity will create a problem. However, if we made the contract flexible, meaning that the obligations will be firm shall, however, to try to shut down or void the relationship, we make it may, to give it more flexibility, so to keep the business relationship up and running instead of destroying it. So you have to bear in mind that. I want you to first take a look at different types of clauses after you draft this contract. Draft the contract, then use your own question to inquire about each clause, and then these clauses I want you to cut and search for the best wording from your own opinion for each clause, like the clause that asks about parties, the clause that asks about the price, the clause that asks about applicable law, and so on and so forth. And then keep the questions plus the clauses with you and file them under the practice area, which is sales contract. Alright, next time we will take a look at the company's law and how to organize this relationship in more details, and how to ask more questions about the different types of clauses. I hope you benefited from this lesson, and will be open to your further suggestions and or comments. Bear in mind that I tried to contact Unigen developers to provide this class in a VR experience that can be shared on Steam. However, no one has responded yet, and therefore my apologies. I had to record these sessions and will provide more information about them later. Thank you.